I'm going to share with you the principles on protection of trademark. As you realize that actually the presentations are somehow intertwined. So the discussion that whoever is going to talk about, maybe I think are going more or less the same on the same line. First of all, I would like to express my appreciation to the organizers for allowing me to share with you. I'm not an expert in this sense, but I'm very passionate about this area. It's an area that I've worked for quite some time. When I did my first research on intellectual property, I think way back in 1997, the last research was done in 1978 by somebody, Wellington, who did on patents in Tanzania. So it's something that over the years I've been quite interested in working on. It's unfortunate that I've never been able to handle, to adjudicate on any case on intellectual property. There was a time I think I shared with Justice Bernard. We sometimes take for granted these subjects. So the trademark case, a copyright case, I saw it a court of appeal. It came before me. So it was only actually I think for stay of execution. And I went to do the judgment. I think the judge was saying actually copyright, like another intellectual property right, needs to be registered, which is wrong. And I said it, I think continuous training like this, I think is very important. And I wish that particular judge would have consulted the other judicial officers, because this actually the decision came even after some of these trainings have been going on. So I thought I should very briefly explain part of that. Yes, I thought I should start with this picture for a good reason. This is the first in-person training that was held in Dar es Salaam with the support of WIPO. And one thing I must say, actually, I must commend our worship Upendo for all the effort that she's doing. Actually, she went for a project there was a training that were held by the WTO and by WIPO for least developed countries. It's normally a training that is done in Sweden. I was participating in that training way back when I was at the university. And that training requires to come up with a project. So it depends on where, of course. So this started as a project that Upendo initiated once she participated in that training in Sweden. It has two parts. You participate in one country, in Sweden, and then the second round you go to one of the least developed countries. Most of us we love to go to one of the European countries, but of course it also they'll go to one of the least developed countries. In that year, they came to Tanzania. So out of that project, this training was conducted. The training you see that was Kisutu. I'm not very sure how many of you were part of that training, but you can see our worship Upendo. I think by then she was still posted at was it Bagamoyo? Yeah, I think by then she had already come, but initially she was working in Bagamoyo. So that was the beginning. That was the beginning of the long journey. We are realizing the fruits today. Oh, sorry. Okay. Yeah. I understand we have different levels of understanding on intellectual property, IP, and everything. When I say IP, there's some ICT should be treated as an internet property. I mean intellectual property. Because when they say IP, it all depends. But for those who are IT field from the IT, they'll think you are referring to the internet protocol. So the reason for the thing Upendo was mentioning, you protect. There are several reasons why you protect intellectual property. The totality of it is the protection of it, because when you develop an intellectual property, there's a research and development. So the R&D, the effort and the investment that is done in research and development, that is the essence of protecting intellectual property rights. So there are two parts. On one part, you protect the consumers. On the other side, you protect the traders. You protect the consumers from being deceived. If you see a product, if I'm buying something, let's say it's a perfume, I know this is actually the perfume that I'm intending to buy. So you can only protect a consumer if that product actually is not a deception, is not a counterfeit product. So that is on the first part. But on the trader's side, or the manufacturers, you protect them because equity, that is something that they own. Although it is not tangible, we call it is intellectual because it's a product, of course, of the intellect. It's a product of the mind. So that is the essence of protecting intellectual property rights. So I will not go delve much into the definition. I know I'm informed that all of you, of course, went through the distance learning program, and you also passed with flying colors. I may not go much, but some of the things, of course, they are in the slide. I'm referring to for the definition goes to a sign, but we'll see later that actually currently it has gone beyond that. We'll see later. Of course, I'll point out actually some there. There's a definition that's provided by the law in Tanzania, but there's a definition under the TRIPS agreement, which I'll also talk about it. So it may cut across. There are so many things. It's a combination. Either there are letters, there may be combination of colors, but there may be combination of letters, colors, and something else. But also we have some taglines. In the past, I think CRDB is the bank that license. It was part of the trademark. Clouds TV, the people's station. So there were those slogans and taglines that were part and parcel of the trademark. But when we went for registration, luckily, actually, one thing I did registration of trademarks. So when we go for registration, they'll tell you actually to disclaim certain words. And disclaimer has its own cost if you go to BRELA. They'll say, pay an extra amount so that you use these words. That means you are using those words. You're saying the use of this word, like the bank that listens, every bank can listen. So you'll be saying, I protect CRDB Bank, but actually I exclude these words. That means the registration of that mark with those words will not give you an exclusive right of using those words. I've seen now CRDB does not have those additional words. So that those taglines in the advertising, there are certain things that are additional, part and parcel of the intellectual of the trademark. I'm having trouble with so basically, of course, that is the section that defines trademark. You see the underlying words and a visible sign. But currently, we've gone actually beyond the visible sign. You'll see later in the course of my presentation. You'll find out actually it is beyond the visible sign. So visible sign, it is defined also under section 2, that visible signs means any sign capable of graphical reproduction. So for us, for a trademark to be registered, it has to be capable of being graphically reproduced. But some other countries, of course, they've developed, they don't require graphical reproduction. You'll see later, I'll discuss actually there's a protection. Currently, they protect smell, they protect sound, they protect motion, and so forth and so forth. So if you are protecting motion, you don't need actually, it's not a visible sign. It may not be graphically reproduced. And that's why I'm saying actually the TRIPS agreement does not contain a mandatory requirement for registration of trademarks. Well, that's very true. It's not necessary to register a trademark. It's not a mandatory to register a trademark. You see later, unfortunately, of course, I'll not be doing the infringement part. I had prepared in my slides, and then when I realized the next speaker will be doing the infringement of trademark. So it's not a mandatory to register trademark, but registration will give you protection. You cannot sue for infringement if you are not registered. You can only sue for passing off, which is a common law. It's a common law remedy. I think the next speaker will speak quite a lot about it. I once actually read a case in Tanzania. Somebody went to the commercial court in the several years past. Went to commercial court, and the reliefs were two: infringement and passing off. But the judge went to section 31, which requires somebody to register. When I read that case, actually, still there was a relief that the plaintiff could have received in terms of, because passing off was, one can prove passing off, because that goes only to the requirement for, it doesn't require somebody to have actually been registered. So in terms of registration, the requirement is distinctiveness. I thought I should speak about this because I will not talk about it later. So in order to be registered for trademark, the trademark has to be distinctive. And because we are talking about deception, you want not to deceive the public in the market. So it has to be distinctive. Section 16 of the Trade and Service Mark Act talks about actually the requirement for distinctiveness. The other thing I thought maybe I should mention, in the past, the law was on a Trademark Act. But over time, because of the development and coming of the TRIPS agreement, which is the trade-related aspect of intellectual property rights agreement, service mark is part and parcel of it. So when I'm saying trademark, I also mean service mark. But for simplicity purposes, when you talk about trademark, you are referring to goods. So a mark that relates to goods, that is a trademark. And a mark that relates to service, that would be a service mark. If I want to register a trademark, a mark for the hospital, that would be a service mark. So I think it better they refer to TM and SM. Trademark and service mark in terms of the registration of the numbers that they refer. So that is because of the development. And then the TRIPS agreement, that is the paradigm shift in the globally. This one came in 1994. What came into it is a part of the World Trade Organization. So initially, intellectual property was not part of the trade, was not part of the negotiation in trade. But later, I think with the development, the US, they are investing a lot in the entertainment industry. So US one, actually, I think they are at the forefront of protecting intellectual property because they are investing quite a lot. So in 1994, the TRIPS came into existence. And of course, we all know that it was a result of the several rounds of negotiation, the Uruguay round, for those actually, the Uruguay round and so forth and so forth. So the discussions went on for so long. That's why our Trademark Act actually came in 1986. It already had those changes. Service mark came as part and parcel of the trademark. So out of the TRIPS agreement, which requires members of the WTO to be a part of the TRIPS, if you are not actually, you don't comply, they give you sanction in the trade. So they tied in intellectual property with the trade. So it became actually, and that's why they call it for trade-related intellectual property rights agreement. So compliance to trademark became actually a part of the requirement. So that's why you find the changes that came in 1986. The trademark, which was the Trademark Act, became Trade and Service Mark Act because service is part and parcel of the trademarks. But also in 1999, of course, we'll talk later of copyright. In 1999, you came with copyright, not only the copyright. The 1966 Act of Copyright did not include neighboring rights. I'll talk later, of course, in the next presentation that I'll do. So the sign actually is defined. It's any sign, combination of signs capable of distinguishing. You find the word distinguishing. Distinguishing, that is very critical because you don't want the consumer to be confused. Because of time, of course, I'll not present a number of things. There was a time somebody registered, I think, because the infringers, they'll come with a word which is more or less similar to the one which is in the market. Like the callers, I know we had a case actually at a commercial court. Yahoo instructed us to defend them. There's somebody who's registered Yahoo, not with the 00, but the U, the W. So it was Yahoo registered in Tanzania, but actually they are deceiving people so that people can think it is the same thing. And in most cases, it will be going more or less to the same products. They'll be referring more or less to the same products which are more or less similar. So service mark, I think, of course, I've just spoken about this. It goes to those services. There's no legal difference between trademark and service mark. In most cases, actually, when somebody talks about trademark, you'll definitely be referring also to service mark. These are the legislations. There are quite a number of them, and I'm glad Her Worship Upendo spoke about them. Of course, the Penal Code, it also applies, because there's a very thin line. The Mechanized Marks Act, that's where actually the people from the Fair Competition Commission are coming into play. There's a provision, I think you see sometimes actually there's a campaign, the campaign of course destroying products that are counterfeit products. It's not done by BLERA, they're doing it fair competition, because actually it's a fair competition issue. If you import a product which does not belong to the owner, that means you're unfairly benefiting from the other side. These are some of the agreements. Actually, you can find the 1883 83 agreement on the Paris Convention. This is the famous Paris Convention. If you talk of trademark or industrial property in the wider sense, then of course, definitely, you cannot talk about it without mentioning the Paris Convention, because that is the genesis of it. We talk about the Berne Convention when it comes to copyright later. We have the Madrid Agreement. Of course, within the regional level, we also have some. Yeah, the Nice Agreement. That is also, when you register trademark, there are classes upon which you register. In those classes, that classification is done by the Nice Agreement. It's the Nice Agreement on classification of goods and services for purposes of registration. So when you are applying, you are saying, oh, I'm applying for this product under this class. So at times, if the classes are not the same, then of course it may not be an issue. If I'm registering a Tiffany school and not a hotel, then am I infringing? Will people confuse the school and the hotel? So sometimes, for that is very important in terms of the classes. But in most cases, the infringer will be infringing in terms of the same services. But also the services may be closely linked with. If you are registering, I think a hotel, let's say a pharmacy and a hospital, they'll be more or less in the same, not necessarily in the same class, but closely relating to class, because they are mostly a pharmacy and the hospital, they do more or less the same thing. One actually offers diagnostic and whatever, and the other one provides medications. The Banjul Protocol, this is for Africa. It is on trademark for Africa, registration of trademark within the Africa. And then we have the ARIPO, the Harare Protocol. The Harare Protocol, the Africa Regional Intellectual Property Organization. There is a OAPI for the French-speaking part, but they all actually deal with the protection. And not only legislation, it is a registration process. In the Madrid and the Halal and the Banjul, it simplifies the registration process. If I want to register my trademark in other countries, BRELA is a designated country. So you can go to BRELA, if I want to register even, let's say, in Spain or wherever, you just go to BRELA, and then I say, I want to be registered in this other country. So globally and at the regional level, they've come up with an approach whereby we can simplify registration process. Because protection of trademark is territorial. You cannot actually say I protect unless it's a well-known mark. I'll speak about it later. So protection of trademark, it is within the territory where the trademark is registered. Unless that trademark have acquired the status of a well-known mark. And there's a judge in the US say that unless you're coming from the moon, everybody knows Coca-Cola. So that is Coca-Cola have acquired a well-known mark status. But failure, less than that, actually, you have to be registered in every country if you want to be protected. I know there was a time, actually, I think one of the competitors in the milling industry, they rushed, I think one of the, I don't know which company, I think, well, I may not mention the names. When you are in intellectual property related, I think the part that they protect much, actually, is not mentioning. Like I went also, I think I was in a radio station. They wouldn't allow to talk about clouds if you are invited by, let's say, another radio, which is not. So what happens, I think that milling company, they had their competitor in Tanzania, so they went to Rwanda, they registered that mark. I think actually they did not win that case. It was in the news. One of the companies, I don't know whether it is either Azam or whatever, they went to Rwanda, they registered the trademark. You go there and then you find it is registered. The same thing they do with the domain names. The domain names, the people actually just go online, they register domain names. You come and they say, would you want to give? Then we're going to sell to you. So this is an area that, so registration basically, the Madrid Protocol regulates registration of trademark internationally. So if you want to register in any country, BRELA can register you under the Madrid Protocol. But if you come to Banjul Protocol, it's for the African region. For the African region, you can get it. They call it designation. So you say, you just tell them, I want to be designated in these other countries. And then, of course, there's a fee upon which you are paying. And registration of trademark, again, is for a fixed term. You register a trademark for a fixed term, you are supposed to renew that trademark. You don't renew, we'll see later, for there's the issue of nullification. One may apply for you to be nullified from the register, and then maybe for him or her to be registered. I spoke about non-conventional trademark when we were dealing about a sign or graphically represented. These are, we currently have actually other trademarks which are not very common, like single color marks, three-dimensional marks. Of course, there are quite a number of things that we talk about, the shapes. I always tell people, if you find a bottle of some of the soft drinks, they're not the same. Coca-Cola is not the same like Mirinda, is not the same like, if that is an industrial design part, the look of actually the appearance of that bottle, it's an industrial design in a way, but also, of course, it may be a trademark in a way. So there's a motion marks currently, so people protect the motion itself. But there are those who protect actually sound marks. And then the other one you follow, my apologies, the smell marks. We all know that smells are not similar. And that's if you're going to buy a certain scent, you are buying a perfume because of the smell, the unique smell that it is in that perfume. So people have gone to the extent of they've started doing registration. I'm informed Tanzania, of course, it's not yet there. They are starting the process, but the point is, because registration of trademark is a process, just like copyright and others, just like patents, you need to have examiners. Somebody will examine in order to say, no, this is not the same like this one. So as long as the technology is not there, then of course I don't think you're in a position to do the registration. I was looking at the position mark, and then the best example of position mark, I think that if you buy, let's say jeans, Levi's jeans, there are certain marks that are positioned at a specific place. So that is actually unique for them, Levi's. But also if you go to Adidas, I think you know the two marks, the way they are located, where they are located. So these are the position marks actually one would want to. These are the manufacturers would wish to protect. The other thing, as I said, if you want to actually there's no requirement for registration, but in terms of registration, actually, if you want to be there are certain things that people may be competing. If you want to protect, is it a question of somebody who was first to register or the first person to use the mark in the market? So that debate, of course, may be there. The moment you go to register a trademark, then somebody may come and say, well, but already, of course, I was in use of this mark. Those challenges will be there. And Upendo spoke about it. The Registrar of Trade and Service Mark in BRELA, it is a tribunal also. So people will go there, the first stage to oppose. If somebody wants to register a trademark, you may go and oppose. They are advertised. Initially, they were doing in the government gazette. It was not widely circulated, so they have their own journal. They'll do the advertisement. You'll give in 7 days upon which to oppose. If you don't oppose after that, they'll register. But of course, even after registration, you can still, I think the people can pursue. But mainly, of course, on the infringement side, on the infringement part. This exception on the first to file and the first to use does not apply for a well-known mark. For a well-known mark, of course, they are very well protected, and I'm glad they shared that. I think the Tiffany is one case, of course, where I think well-known mark was started to be discussed, but otherwise, it was not very grown. It's an area that was it was very virgin area in that side. Of course, in terms of there's a protection of the trade names, which do not require for trade names do not require registration for member countries, of course, the Paris as well as the WTO. The other thing that I thought I should talk about, I think I've just said it, but it's not compulsory to register. So once the registration is done, you are protected, you acquire the exclusive rights. Section 31 and 32, they are very much important when it comes to, especially, of course, on the relief. If there's a case before you on trademark infringement, the relevant provision, Section 31 and 32. I know you are getting trouble with the never bother about that mark. Yeah, so definitely, of course, but Section 14, that is very important because Section 14 talks about, of course, the requirement to register. And once you are registered, I think, in law we are saying actually, if you don't seek protection of the law will not protect you. And that's a good example. If you don't register trademark, unless you sue under the passing off, but actually you cannot sue under the, it is not an infringement. If you go for infringement, then of course there's no cause of action. Because the first thing you have to prove, if you go for infringement, is that this mark, I have a mark that has been registered. So once, of course, so registration, actually, that is the proof number one. So that is very, very important, of course, for all of us to understand. And these are some of the things, of course, in terms of once a trademark is registered, of course, the owner has exclusive right. But that exclusive right, of course, it is an exclusive right, of course, for many things. You have exclusive right, of course, over all others who are not registered. And a trademark or a service mark, it is a product, any other product. So you can dispose. In fact, if a company is being sold, whichever company, there's evaluation of trademark that the intellectual property that the companies own. We don't have so many valuers actually can do that, but definitely that is one of the products that the company will be doing evaluation, that any trademark that are there with a copyright, patent, and so forth and so forth. Those are some of the things that will be done. And normally, one of the things you can dispose a trademark by sale, by licensing, by assignment, and so forth. I always tell people, if you find the late Mengi, most of the business was doing, the trademark were not new. You go for Guardian. Guardian is it's a UK company. ITV is a UK company. So most of the things, most of the product Mengi was doing, actually, it was under license. But the condition for license is on the quality. You can not license for somebody whose quality will be low. If you go to Subway, I think the quality of the sandwich should be the same quality of the sandwich that you get in New York or elsewhere abroad. So all those franchises, if it's KFC, whichever, if it's, let's say, even if toothpaste, so the quality must be, you have to maintain quality. In one part, of course, you are protecting the consumers so that the consumers can get the same quality that they're expecting the product must be able to represent the quality of the mark. So there are two categories of license. It is non-exclusive license and exclusive license. In non-exclusive license, it doesn't prohibit you. License to somebody, and the owner or the manufacturer still is able to either use himself or herself, but also license to others as well. But the second category, exclusive license, that it prohibits actually the owner or the manufacturer from using, but it cannot give other room for further licensing. But definitely, of course, in most cases, the manufacturers want actually the other one, which will give them room to go to keep on sharing with others. So well-known marks, luckily enough, our worship Upendo spoke about the other one. Well-known marks, these are marks that are known globally. I gave an example of Coca-Cola. Everybody knows Coca-Cola ever since we were born, and I always tell people, Coca-Cola smart. If you look at the advertisement, they're not focusing on you, they're focusing on the kids. Because for them, they've already gotten you, they are looking for the market in the next 50 years to come. That's why during Christmas festivity, you see them, the kind of the Father Christmas. Actually, they want to attract the kids who don't know that product. So TRIPS agreement, Article 16, and Article 16, of course, but also the Paris Convention, Article 16b, they all talk about the recognition or realization, recognition of well-known marks, which is not actually, it is not part of our legislation, but as much as we are part of the TRIPS agreement, we are part of the Paris Convention, so we are bound. We are bound by the Paris Convention. All of them actually they prohibit using similar, any sign similar to a well-known trademark globally. So definitely, of course, the aim is to protect. I'll just discuss very shortly the category, what one needs to prove in order to indicate that this trademark is well known. So in our jurisdiction, of course, we do not have several cases that have been decided, but at least, of course, we had one. So the international standard protection well-known marks, these are clearly spelled out in both the TRIPS. So the conditions, of course, have indicated that one is the degree of knowledge of the mark. Do we really know this mark? Or that is one important thing to consider. But the duration and extent of its use, for how long have it been used in the market? If you ask about Coca-Cola, we were born, all of us were born, of course, knowing that Coca-Cola is there. The number of registration for it worldwide, has it been registered? How many countries have been registered? Of course, there's always, if it is a matter that comes before the court of law, he who alleges must prove. So the one who comes before you will be proving those elements. That this trademark, of course, is well known in terms of the knowledge of the mark. Everybody knows, therefore, it's upon you are going, It's a proof of it's a witness proof. The duration of the extent of use for that will be also something that can come out of out of evidence. The number of registration, again, one will be indicating, of course, you have to show the diligence within which the owner can prove he has defended this against copies, and yeah, that is another issue. The case that Honorable Pento, I think, mentioned, I'm not very sure whether it's that or not. There was another dispute before, WIPO Arbitration Tribunal, where there was a dispute on over the use of domain names. One thing I realized, actually, if you go to the manufacturers, yes, it's the same. What happens? If somebody have a mark, we register a trademark, also they register the domain name. At one point we visited, when we went for that training, WIPO training, they took us to SmithKline Beecham, this famous multinational pharmaceutical company. What we found out, when they produce every product, they are registering a trademark, but also a domain name in the website. So you have no way out, you can go in the website and register that domain name. So with the Tiffany, I think there was a dispute also before, the WIPO arbitration, but also they won there. So that was an additional, it was a plus when they came before the court in Tanzania. I'll not talk about that case because lucky enough, he has already actually spoken about it, the Tiffany. But the other one is the commercial case that was before Madam Justice Philip. The commercial court. It's a dispute. This is the JC Duke is a company that had been, it's a family company from the Paris. That's way back, I think, in 1964. They have investment in South Africa. They have a company in South Africa. They registered a company in Tanzania. So somebody actually, I think, he came with a company that was JP. Because so you find that the difference actually is JC and JP. So and it was the same business, all of them doing the outdoor advertising. So it was quite clear that although actually it is not part of our law, but what I was saying in the last paragraph, this was a paradigm shift, because initially we were looking actually infringement under Section 31 of the Trade and Trademark Act, but now we have a case which is now we have actually a well-known mark before us. So that case, the plaintiff won. And we've not seen actually anything before the Court of Appeal, and that's why we were comfortable, of course, discussing about it. Yeah. Finally, I was requested to speak about trademark cancellation. Trademark cancellation. At which stage can you cancel the trademark? People may apply actually for a trademark to be removed. I think normally it's better they use the word application for removal of a trademark in the register. The Registrar of Trade and Sales Mark has a register of all trade and sales marks that are registered in Tanzania. So one may come and then request that, well, they want the trademark to be removed. And that's why I told you, if somebody does not win, or somebody does not win the case during opposition, you are not late. You can still come actually to apply for removal of the trademark in the register. So if I were a business person or a lawyer, you are not late actually. If you cannot do at that stage within that 60 days oppose, then of course even after registration, you can apply for removal of that trademark from the register. And there are a number of things that you need to prove before the registrar. One is that if the trademark is not being in use or it has been abandoned. There are people, of course, well, I remember way back, I think I saw Aereo in the year 1990s. Aereo, we remember the soap. But actually it was registered in 1970 in Tanzania. So one may have to say, well, the trademark have not been in use or the owner has abandoned. There has been cases actually you may apply and then there will be nobody to be seen to object, then of course you win. But in most cases people will come and defend. Then of course loss of distinctness, because we said Section 16, a trademark can be registered only if it is distinctive. So one may say, no, it is no longer distinctive. So if you are able to prove that the mark is not distinctive or it has become generic, we always talk about it. There are several few examples. Shell was it was actually a registered company, but later it became famous, Anaconda Shell. So Shell lost actually that distinctiveness. The same thing is Thermos. Thermos is a trademark. But if you tell somebody, can you bring me Thermos? So Thermos become actually a name associated to a product. No. So definitely sometimes you even Sometimes if you're advising actually the owners, you advise them actually to make sure that at least they make it so much unique so that it does not. So something becoming generic, it's common. There are so many drugs that are becoming generic drugs. They are generic because bring me Panadol, even if for somebody it means something else, not only Panadol. So basically, once they acquired the generic status, they are no longer actually protected. It's very common. It's unfortunate people from there are not here. It's an area that I did some. Definitely, in medicine, there are so many medicine that they have become generic, so they lose, they can no longer acquire that exclusive status, they can no longer be protected because they are very generic in the market. Of course, fraud in registration or nullity, there may be a mark which a fraud was used in the registration process. So you're saying, no, this was nullity from the word go, so you apply, you want it to be cancelled or to be removed from the, but also failure to observe the condition for registration. Because once you are registered, just like the ownership of land, there are certain conditions that the owner must fulfill. If you don't fulfill those conditions, one of which, of course, you are supposed to renew after every 7 years, I think so. You are supposed to renew. If you don't renew, then, of course, one may apply. When you apply, one may say, well, this is it is no longer, the owner have not complied with the requirement for use, so that will be the basis actually for one to be registered. Thank you very much for listening. I hope I've been able to keep the time.